In your opinion, and in light of your own recent research, what are the key factors that a competition authority should consider when assessing the impact of a merger on innovation? More specifically, how would you classify the Dow-Dupont merger more than a year on from the Commission decision? Is it an evolution in the framework for merger assessment, or is it a revolution in how to factor innovation into merger control?
Thank you. Thank you, first of all, for the invitation, and happy birthday to the Autoridade da Concorrência, 15th year. The evolution versus revolution, being an official of the Commission, I have to say it's an evolution. It wouldn't expect anything different, also because the Commission had tackled innovation issues in many decisions in the past. What is true in the Dow-Dupont decision is that we went quite deep into the assessment of innovation concerns. And as you probably know, also the remedy that we decided in the end that the merging parties had to offer involved the divestiture of the global R&D facilities of Dupont. So it was a very large remedy in that sense, and we went deeper than the usual analysis you find in these industries where you look at overlaps in products and pipelines. We went also one step further, analyzing the overlaps they had in fundamental research. So not just the D in R&D, but also the R leg. The case of Dow-Dupont, in my view, is very interesting. The Commission got its hand really dirty on the facts of the case, and we found that in that specific industry there were only 5 global players that had the capability of doing innovation. Innovation also is an important parameter of competition in the industry. There is no possibility of further entry in the years to come because of capabilities, because of the huge fixed cost. And then we also looked, interestingly, that the companies in this industry, at least, were not throwing money at random trying to invent something, but they had very precise targets. So they were looking for a specific combination of crops, wheat, and pests, say insects. And this targeted innovation areas were also something they would monitor each other. So they would look at the patents that each company would have in a specific technological trajectory. And so we did some interesting analysis using patents and patent citations, and we actually saw that in some areas actually those 5 firms, they were not all competing against each other, but there were only 2 or 3. So in some instances, it turned out to be a 3-to-2 merger or a 4-to-3 mergers, because the parties had very strong overlaps in specific areas. So these are important facts of the case. In this context, we were asked to look at the economics of it. And economics, I think what we did was also particularly useful to clarify some misconceptions. In a case like this, you would start with the advisors to the parties saying, well, in innovation, high prices from a merger may be good because this may give higher profits and it may give a higher incentive to innovate. In fact, the literature says that anything can happen. If you actually look into the specific literature on mergers, you don't find anything of this. And what was useful, I think, was to refocus our attention on unilateral effects. And what do I mean by unilateral effects? So when firms compete against each other, they would set a certain low price to drive away customers from a rival, or they would want to innovate in order to drive away customers from a rival. It's a normal business stealing effect that we understand very well in prices, and a similar business stealing effect also arises for innovation. So if those two parties merge, this innovation externality would be internalized, and they would have less of an incentive to compete against each other. So this is an idea that goes back to Arrow, and it's quite strong. It had been also mentioned by several policy commentators, Shapiro, Jonathan Baker, also Howard Shalansky, who's here at this conference. But there was a little bit of a lack of formalization. So what we did, we went back to pen and paper, and we did some models that show exactly what I just said. It's very, very difficult, especially if you adopt a consumer welfare standard, which is another theme of this conference, to find a situation where a merger would be good for consumers, even if you consider the impact of innovation. So overall, there is a lot of good economics that would say that we should have a concern. So this is also good economics. So we also derived a roadmap, a limited a limiting principle framework which is useful for future cases. So you would want to see, to simplify, of course, you would want to see whether innovation is an important parameter of competition. So in some industries, pharma, agrochemical, semiconductors, etc., this is the case. In cement, it's probably not. So you have to tick these kind of boxes. Then you want to see whether there's possibility of entry. In some industry, it might be possible, so the concern would be reduced. If it's not possible for several reasons, then you may have a concern. You want to see, as I said, a standard closeness and overlaps. So here the difficulty, if you want, is to understand the capabilities of firms to do research. Where do they come from specific scientists, from general purpose technologies. But if you find closeness in the R&D capabilities and also overlaps in those capabilities, if you have a limited number of very close competitors that are the only ones that can do innovation, again, you would say that your competition concerns are stronger. You also want to look at appropriability. So to the extent that when people innovate, you have to ask yourself the question, is this firm going to retain the profits from the innovation? So are they going to get a patent, or can they license the innovation, or is it through industrial secrets? If there is a good protection of intellectual property, for instance, we thought that in the agrochemical that was the case because there's strong patents there, then you have a case where spillovers don't really play a big role. Involuntary is a spillovers. And of course, conversely, instead, if spillovers are very big in an industry, then the merger may have beneficial effects. There may be beneficial effects if innovation are complementary to each other and not substitute. Again, this seems not to be the case in the Dupont. There may be all sorts of efficiencies coming from a merger. So there is also strong reasons that I would frame under the efficiency defense that we have to take into account in technologically intensive industries. But here the question is who should bear the burden of proof of showing the efficiencies. And I think because they rely on some inside knowledge on the industry, it probably should come from the parties themselves, because economists, lawyers, we don't know much about specific industries. Even if at Comp some of my colleagues became excellent experts in the agrochemical industry, of course. Then I also want to conclude that in the specific case in Dow DuPont, I don't know how this will be in future cases, we found quite some strong, unprecedented evidence that the parties themselves were planning to cut R&D, cutting scientists, cutting R&D budgets, and cutting also the aspirations. They were also want to not just the R&D input, the effort they would put, but also the number of AIs, active ingredients, which is an output measure that we're trying to put on the market. They were saying quite explicitly that after the merger they would have reduced it. This also was a very important factor in the decision.